With me in studio today is Richard Meyer from Fullard Meyer Morrison Incorporated. As we know, Fullard Meyer Morrison are our drafting attorneys for our commercial, lease pack, and our HPAC. Richard, you're an attorney, you're a specialist labor law attorney, and you've been an acting labor law judge.
That's correct.
Wow. So today we're going to have a chat about virtual retrenchments.
Right.
And it seems quite scary, and I thought maybe we could set the scene with talking about coming out of 2020, and the amount of job loss we've experienced was huge. 2.2 million jobs lost in quarter two, 1.3 million jobs still lost by the end of the year. And for an employer, many employers have not made it through into 2021. And so those that are restructuring, retrenchment is an obvious way to look at the process.
Correct.
Talk to me about retrenchments.
Unfortunately, the reality is, Michelle, that one's payroll as an employer is one of the biggest overheads in one's business. And so when times get tough, people look at payroll, management looks at payroll, and one looks to ways of reducing one's overhead by cutting one's staff. And one would have a restructuring exercise where one determines certain non-key functions or less important functions, which one will then cut in the restructuring process. And what the retrenchment process involves is implementing a procedure and a process whereby one consults with the employees or their representatives. And the essence of the consultation is a joint problem-solving exercise to avoid the retrenchments if at all possible. But if that is not possible, to mitigate the adverse impact of the retrenchments on people. So one can negotiate higher severance packages, the timing of the retrenchments, or any additional assistance that the employer can give to the employees in
Those
the process.
that are being retrenched.
Correct, if it does go ahead, unfortunately.
So talk us through the steps along the way, the journey along the way. Where does it start?
So essentially, when the decision is made or the possibility arises that the employer will be engaging in a retrenchment process, a Section 189 letter is issued to an employee, or if there are a number of employees, it's a Section 189A letter where it's a mass retrenchment. And then through the process, the various items for consultation, particularly the ways of avoiding the retrenchment and any other aspects relating to the retrenchment, are negotiated on and consulted on with the employees or their representatives. And then in the process, certain issues can lead to deadlock, but ultimately the employer is not required to accede to all the demands of the employees or their representatives. But if it does not agree, it must give good reasons. And then ultimately, if the retrenchments cannot be avoided, the retrenchments will become final after completion of the consultation process.
So there was a recent judgment, Labour Court judgment, during the 2020 lockdown year.
Correct.
And that judgment has had far-reaching consequences, thank you, of this retrenchment process, because it may now be done virtually.
Correct. So this case, it was FAWU, the South African Food and Allied Workers Union, versus SAB, the South African Breweries. And what happened is that prior to the lockdown and the impact of COVID-19, SAB had already decided on a restructuring process where job losses could occur. And they embarked on a retrenchment process. They issued the Section 189A notices because it was a mass retrenchment. And this was a month or two before the hard lockdown in March last year. And then...
so this process preceded...
Correct.
Even the lockdown.
So it preceded the lockdown, correct. But then the lockdown intervened and the retrenchment consultation process had not been completed. And what then happened was, because it was a mass retrenchment, you appoint a facilitator to assist the process. And SAB and the facilitator wanted to proceed and continue with the retrenchment consultations during lockdown, but over Zoom. And the Food and Allied Workers Union objected, and they said, no, they must wait until the end of the lockdown, until a place or time when they could still consult face-to-face with the facilitator, SAB, and the other interested parties. And the SAB and the facilitator decided to go ahead without them on Zoom and conduct the continuation of the retrenchment consultations on Zoom. This then led FAWU to approach the Labour Court on an urgent basis to try and stop the retrenchment process until face-to-face consultations could resume. And then it came before Judge Mashwana in May last year. And I think the death knell and the way the judge was going to be looking at the matter occurred very early in his judgment, when he indicated that it was ironic that although FAWU did not want to continue with the retrenchment consultations on Zoom, the matter was being heard on an urgent basis on Zoom before him. And essentially what Judge Mashwana found in his judgment is that because of the threat of COVID-19 and the necessity for social distancing, that measures such as Zoom must be applied to ensure the protection of all concerned and prevent the spread of COVID-19. And he mentioned that this situation was becoming the new normal under COVID.
So what we've had then is we've had a process of a retrenchment process that the judgment has now said that these retrenchment process consultation processes can happen via Zoom. And if the employer and the employees still can't agree on all their requests, that at the end of that we can go ahead and the retrenchment process can take place. How does that affect other types of disciplinary actions or other types of labor disputes?
That's a very good question. Essentially, the precedent set by the judgment applies strictly to retrenchment consultations, but I would argue that the impact of the judgment is that it's starting to set a new normal and a trend which would extend to things like disciplinary hearings internally, and even the use of such technology at the CCMA, which is actually happening. The CCMA actually allows you, by agreement between the parties, to go online and have your hearings online. And in the Labour Court, the standard and the norm is to have your hearings online, virtually. I've had two applications which I've argued on Zoom already. But that was at the Labour Court. But at the CCMA, different considerations apply. A lot of people, a lot of employees who go to the CCMA do not have access to the online platforms.
It was going to be my next question. What about then those employees that don't have access to this type of technology or data in order to use this technology? How does that impact them?
Well, unfortunately for an employer, the reality is that if one has white-collar workers who have access to the online platforms, have access to laptops or even smartphones with Zoom or other applications on them, obviously one could expect them in normal circumstances to conduct the disciplinary hearings or any other HR processes on these online platforms on a virtual basis. But where one is dealing with manual workers or blue-collar or factory workers, one would probably have to have the face-to-face hearings, unfortunately, and then observe the appropriate social distancing. So the CCMA, for argument's sake, when it goes to CCMA, I was there in one chilly winter's morning because we had to go there physically, and one had the long queue outside the CCMA because there's no alternative for some employees other than to have a face-to-face hearing in a disciplinary or face-to-face arbitrations at the CCMA.
So I guess the message is, when we were under the hard lockdown period and movement was restricted, so we couldn't move, your only option is a virtual Zoom type environment.
Correct.
In the current situation at the moment, where we're only in alert level 1 and you are allowed movement and face-to-face meetings, you then have the benefit of either choosing whether it would be face-to-face or if you could proceed with a virtual Zoom type meeting.
Correct. There would be an option, but of course, when one is dealing with the CCMA or an employee, the employee might object, and that objection could be in good or bad faith. My particular view is we should consider inserting in terms and conditions in one's employment contracts or in one's disciplinary code a clause to the effect that unless there's reasonable objections, an employee who has access to the online platforms should consent to disciplinary proceedings being conducted on Zoom. But of course, there could be circumstances where the employee could be prejudiced by conducting the proceedings on Zoom, such as where they need to lead witnesses who aren't available online, or where there's a lot of documentation which isn't easy to share online. So one must deal with it on a case-by-case basis, but I do feel that the trend that is emerging from this process is that even after the risk and threat of COVID disappears, I think one will find more and more online hearings in internal disciplinary proceedings and other HR processes.
And of course, in terms of that, Richard, we've amended the TPN HR pack with your guidance to bring those type of changes into the documentation, both the code of conduct and the agreements.
The contracts of employment.
Fantastic. Thanks, Richard, as always. We appreciate your guidance and clarity on labour issues. In closing, a reminder to download the latest TPN HR documents from the TPN shop. And remember to ring the bell and subscribe to receive all of our YouTube content.